What's going on, everybody? Soliaka here, and I received this from 863 Media, and I want to say thank you very much for sending this to me. And this is the memorandum that Mr. David Levin, the city attorney, this is what he was referencing.
Questioning the constitutionality of our ordinance as it relates to concealed weapons. And I presented yesterday a legal opinion addressing that. I was not expecting it would be up for discussion today. And I've asked the city manager to send you a copy of that opinion.
And he is right. There is a preemption against firearms. But what we are going to talk about is that he still can't create regulations pertaining to weapons. And we're going to go through a lot of this right now. Now, their ordinance reads, whoever in the city of Punta Gorda shall carry a concealed weapon or electric weapon or device on or about his person shall be guilty of a misdemeanor in the first degree. Now we're going to talk about numerous sections, numerous statutes that allow people to conceal carry these devices in the state of Florida lawfully. Now, we're going to talk about 790.25, Section 3, and we're only going to stick to Section 3 and what it says. Lawful uses. The provisions of 790.053 and 790.06 do not apply in the following instances. And despite such sections, it is lawful for the following persons to own, possess, and lawfully use firearms and other weapons, ammunition, and supply for lawful uses. And then you can go to Section H. So, by definition, I am lawfully allowed to conceal carry or openly carry any type of weapon or firearm under Florida law. So, once again, your ordinance violates state statute, and you can't do that. There may not be a preemption for it, but you can't just create laws that prohibit me from doing what I'm doing under this statute. Alright, let's talk about 790.01, unlicensed carrying of concealed weapons or concealed firearms, except as provided in subsection 3, a person who is not licensed under 790.06 who carries a concealed weapon or electric weapon or device on about his person commits a misdemeanor or first degree of the first degree. And basically, if you guys really pay attention to it, this is what they're trying to do right here. This is their ordinance, is 790.01. And like I was saying, under section 790.01, section 1, except as provided in subsection 3. Well, let's go to subsection 3. Alright, section 3 reads, this section does not apply to subsection B, a person who carries for purposes of lawful self-defense in a concealed manner. 1. A self-defense chemical spray. 2. Non-lethal stun gun or dart-firing stun gun or non-lethal electric device or electric weapon or device that is solely for defense purposes. He also goes on to quote 790.33, the statute provides a pertinent part. It is the intent of this section to provide uniform firearm laws in the state to declare all ordinance and regulations null and void which have been enacted by any jurisdiction other than the state and federal which regulate firearms, ammunition, and components thereof. And under 790.06, section 16, the legislator finds a matter of public policy, in fact, that it is necessary to provide state-wide uniform standards for issuing licenses to carry concealed weapons and firearms for self-defense, and finds it necessary to occupy the field of regulations of the bearing of concealed weapons or firearms for self-defense. That right there just proves my point that they cannot create their own weapons ordinances, especially if they are licensed to carry a concealed weapon. The next two statutes he quotes are just definitions of a concealed firearm and a concealed weapon. 790.001 are just the defining terms of all of this. And then he goes on to quote Snow versus Rudin. These are federal court cases that deal with definitions and how the law is written in their wordage, in their verbiage, and so on and so forth. But it doesn't matter about verbiage when the state is the one that's in control of regulating all of this. Period. All right, these are my final thoughts. As you can see, under these laws, especially 790.06, the licensing of concealed carry of weapons and firearms, we are issued a CWFL, a concealed weapons and firearms license here in the state of Florida. This lawyer is not doing himself any favors. There may not be a preemption directly for firearms, but the legislation is the state and federal law are the only two people here in the state of Florida that can control weapons and firearms. Just because there's not a preemption doesn't mean you're out of the woods. So, you know, I don't know where you got your law degree. I'm not a lawyer, and I think I've kind of panned it out a little bit better for everybody. But this guy, he's off his hinges, and I guess we're gonna have to do something about this, because he can't keep doing this. He tried to restrict people's First Amendment right, and now he's trying to create ordinances where he's gonna restrict your weapons rights. You know, he's lucky. I guarantee if he had the choice to restrict weapons or firearms, he would have done it a long time ago. And that's why he's trying to piddly around with the wording of these things, which, guess what? Even with the wording, legislation's already told you that you can't do this. So keep, for anybody out there, I have gotten quite a few emails about this, and I will be reaching out to those people, and we will be talking, because I think this is something that needs to be dealt with. So I'm out of here. Don't forget, hit that like, share, and that subscribe button, all that good stuff. And I'm out. Soliaker. Deuces.